All right, now we are going to get started. This is Layla Shaver. This week we are talking about advertising and reporting. So let's go ahead and get started. We are on Q&A mode. Just have to dial *6 to raise your hand and ask questions. Otherwise, you can message me directly if you want to ask questions. Go along. Let's get started. So the advertising rule prohibits advisors directly or indirectly from publishing, circulating, or distributing any advertisement that contains any untrue statement of material fact or that is otherwise false or misleading. And you can find this general definition under Rule 206-4-1. Now, an advertisement itself is going to be any notice, circular, letter, or other written communication addressed to more than one person, or any notice or other announcement in any publication or by radio or television. Statements made through electronic media or other non-traditional means are going to also fall within the purview of the advertising rule. Now, the advertising rule does outline 4 specific prohibitions, and you'll see those listed. First is testimonials. I think most advisors are the most familiar with this. Hey, sorry guys, I got bumped off the presentation. Okay, so there are 4 specific prohibitions that are outlined in the rule. The most familiar for all advisors I have found is the testimonial, and that's any testimonial concerning the advisor or any advice, analysis, report, or other service rendered by the advisor. Now, this comes up a lot nowadays with social media and different social media platforms. Generally, anything you can control, you don't want to allow or publish any sort of testimonial regarding your services or how you are as an individual. There are certain platforms where you certainly cannot control that people are posting reviews or other information about you individually or your firm. That's fine. Really where regulators are concerned are in the platforms that you do have control. So I think with, Facebook, you can actually turn off the ability for folks to post on your Facebook page, or you can make it so that they have to be pre-approved, the post has to be pre-approved. And that would be one example of a way you can kind of control whether clients, potential clients, or anyone who's just had an interaction with you is able to post any sort of testimonial about you and your firm. Another specific prohibition in the advertising rule regard past specific recommendations of the advisor that were or would have been profitable to any person. The third is claiming any graph, chart, formula, or other device can by itself determine whether to buy or sell a security. And then any offer of free reports, analysis, or services is also going to be prohibited by the advertising rule. And this whole issue of free has certainly come up several times with a lot of our clients, and it continues to come up in routine examinations with advisors. Because the idea with the free is that it's not truly free. You know, for example, if you say you have free consultations, regulators have taken the position that it's not really free because you're bringing them in and then you're trying to sell a service to them at the consultation. So really, truly, it has to be no strings attached. And with a lot of our clients, we've gotten away with synonyms, basically, to escape kind of this whole idea of using the word free and saying that they're not being charged for the consultation time. So essentially, it's free, but very clearly, you know, defining what the free is, that you're not paying for the advisor's time. So these are 4 specific prohibitions that are in the actual rule. Now, there are a lot of compliance issues that come up with advertising. These are the ones that happen the most frequently, that are identified by the SEC when they've gone out and done examinations and kind of look at what's coming up the most. So with misleading performance results, the SEC has noticed that advisors are presenting performance results without deducting advisory fees. They're also seeing these ads compare results to a benchmark, but then don't include disclosures about the limitations that are inherent in such comparisons, including instances where, for example, the ad did not disclose that the strategy differed from the composition of the benchmark to which it was compared. There's also issues with hypothetical and back-tested results in that they aren't coming with disclosures that explain how the returns were derived or any other kind of potentially material information regarding the performance results. Another frequent compliance issue, misleading one-on-one presentations. So an advisor has advertised performance results, growth of fees, in certain one-on-one presentations, but then they don't include relevant disclosures. For example, that the performance results do not reflect the deduction of advisory fees, and that the returns that they're being shown would actually be reduced if such fees and other expenses were deducted from the numbers. Another common compliance issue, misleading claim of compliance with voluntary performance standards. So when an advisor has claimed their performance results comply with a certain voluntary performance standard, when it's not clear if the results in fact adhere to the guidelines. A common example of such a voluntary performance standard is the Global Investment Performance Standard, or GIPS. So the SEC has found that there are advisors that claim in their advertisement that they've complied with GIPS when they in fact haven't. Another common compliance issue that's come up with the SEC, cherry-picking profitable stock selections. So, for example, advisors that are only including profitable stock selections or recommendations in presentations, in their client newsletters or on their website without providing perhaps a list of also the least profitable stock selections. So in this context, if you want to talk about your stock selections and what you've recommended in the past, you can set out to offer, or you can actually give a list of all the recommendations you've made as an advisor during the preceding year, but you have to have certain specific disclosures about those recommendations. So, for example, the SEC has seen advisors that disclose past specific recommendations, but they don't include all the recommendations, and so they don't meet the conditions that are required if you do want to put forth these different recommendations you've made in the past. And essentially, you have to present an evenly balanced list. So if you're going to list your most profitable, you have to list your least profitable. There was a no action letter, the TCW Group no action letter. And in that no action letter, the SEC said that an advisor that advertised to consultants, prospective clients, and existing clients who were not invested in a particular investment strategy, the 5 best performing holdings along with an equal number of worst performing holdings, then the advertisement would be okay. Where the issues come up are, again, there's not that evenly balanced presentation. There's another no action letter. It's the Franklin no action letter. No enforcement action was recommended for an advisor to advertise past specific recommendations by using a methodology that was consistently applied, objective, and based on non-performance-based selection criteria. So that, again, an even presentation of the selection of recommendations you're showing to a potential client. Another compliance issue that's come up frequently are with compliance policies and procedures, which kind of comes up in almost every single deficiency we see coming out of the offices of regulators, is that the compliance policies and procedures fail to put forth policies and procedures that would prevent the deficiencies that were noted. So a lot of advisors did not have or did not implement policies and procedures where they had a process for reviewing and approving advertising materials prior to their publication or dissemination. When using composites, determining the parameters for which accounts were included or excluded from performance calculations, and then confirming the accuracy of performance results in compliance with the advertising rule. So again, those are 3 processes, procedures that really need to be in your compliance manual, and that regulators have noted a lot of advisors failed to implement or did not have. So I want to go a little bit into a deeper dive on disclosures when it comes to discussing returns. In this case, we're going to talk about actual returns. So a lot of advisors want to talk about the returns that their portfolios are making for clients, and they use that as a way to bring in new clients, to convince someone to sign on to their firm. So this is a list of things that have come up with our clients that we've seen regulators take issue with, and it's the different failures when it comes to disclosing, making important disclosures with your actual return. So when you fail to disclose the effect of market or economic conditions on the results, The actual results, as we mentioned before, don't reflect the deduction of advisory fees, commissions, and other expenses. Failure to disclose whether the results reflect reinvestment of dividends. Failure to disclose the possibility of loss when the advertisement suggests or makes claims about the potential for profit. Failure to disclose all material facts when providing a comparison made between your actual results and an index. Failure to disclose whether any material conditions, objectives, or strategies used to obtain the actual results portrayed, and whether there are certain circumstances that gave the returns that couldn't be repeated again. So, you know, we have a market curve that's once in 100 years, and we got the returns that we're showing our clients. We would have to disclose that, you know, we had this once in 100 years, you know, surge in value, and that that overwhelmingly affected the returns that we're portraying. Failure to disclose that the portrayed results relate only to a select portion of your clients, the basis on which the selection is made, any material effect of this practice on the results. So again, you want to make sure your client or potential client that you're showing these actual results to really have the appropriate, fair, even-handed presentation of what those results mean, the context of those results, how, you know, if there was anything that happened that may have been unusual or not easily repeated, so they understand the context and they understand how those results were obtained. You can use model results in your advertising so long as the advertisement equips prospective investors with additional information in light of the heightened chance that model results may create erroneous inferences about future returns. You'll want to make sure you're making the additional disclosures that I have listed here when presenting these model results. So you want to disclose any limitations inherent in your model results, especially if they don't reflect actual trading and may not reflect the impact of, you know, material, economic, and market factors that may have had an effect on your decision-making when you use actual client funds. You have to disclose conditions, objectives, or investment strategies of the model portfolio that may have changed materially during the measurement period, and if so, the effect of any change on the portrayed results. This came up recently with another client of ours where they were showing model results for a portfolio that had materially changed since the model results were originally created. So the model results were no longer effective and no longer serving the client because it didn't actually reflect the material changes that had been done to the portfolio. So, I mean, they couldn't use it because it was misleading in nature. You must disclose that your clients have actual results materially different from the results portrayed in the model. So again, the key word in a lot of this is material. So things that would affect the potential client or client decision-making, you want to make sure that you're providing that information. Again, providing context, making sure it's an even-handed presentation of the facts, and providing all the necessary disclosures. Another kind of issue that comes up is with hypothetical back-tested performance. You should be very, very careful when presenting back-tested performance. Although it's not prohibited, the SEC, it raises a red flag with them, and not just the SEC, and this is applicable to state regulators as well, and should really only be presented to sophisticated clients and prospects. Guidance from regulators is kind of light in this area, but we know of cases where advisors have been disciplined for failing to disclose the following list in connection to the advertisement of back-tested performance. So you must very clearly disclose that the back-tested performance was derived from the retroactive application of a model developed with the benefit of hindsight. The reasons why the actual results differ, and inherent limitations of the data, whether the trading strategies retroactively applied were not available during the periods presented, if applicable, that actual performance of your client accounts were materially less than what the advertised hypothetical results are, any material economic and market factors, again with whether the performance reflects deduction of fees, commissions, and other expenses, all material facts relevant to any comparison between the back-tested performance and the benchmark, and then very clearly you want to always state the potential for loss. And you want to make sure all these disclosures, you don't want them in teeny tiny font that you need a microscope to read. These need to be prominent, they need to be visible, they need to be easily read. If you deal with a lot of elderly clients, older clients, maybe you want to have, a blown up version of the disclosures that you can give them. The example that kind of comes to mind, I don't know if you guys have ever seen the commercial of this couple that goes to a restaurant, they're given menus, and they forgot their glasses. They ask for the menus with bigger font, and the waiter comes back with these huge menus for them to read. You want to make sure that your clients see them, understand them, and to address any questions they may have about how you're showing them performance results. So I just wanted to go through actual hypothetical or actual model and hypothetical back-tested performance results, but those come up a lot with our advisors and when they're trying to market their services. So another kind of issue that comes up with advertising are accolades and awards. So the SEC launched this touting initiative in 2016 to examine the adequacy of disclosures that advisors provide to their clients when touting awards, promoting ranking lists, and identifying professional designations in their marketing materials. And they launched this touting initiative in response to the regularity in which the SEC staff saw advisors advertising these accolades without really disclosing any facts about what they are or how they were obtained. So, misleading use of third-party rankings or awards. These can be potentially misleading because they may contain references to awards or rankings conferred by third parties that fail to disclose facts, which the SEC may believe are material about such awards or rankings. So, for example, advisors advertise accolades that have been obtained by submitting potentially false or misleading information in the applications for those awards. Advisors publish marketing materials that reference sale, ranking, or evaluation information, thus potentially misrepresenting the advisor's current status. So, for example, advertisements that refer to an advisor receiving a high ranking in a publication, but the publication was issued from several years ago and the rankings were no longer applicable. So if you won, 2018, best advisor in Oklahoma, then you can advertise that in 2018, 2019, maybe going into 2020. Certainly you want to continue to use it beyond than to say you won it in 2018. The issue comes up when you say we're the best advisor in Oklahoma in 2025 when you won it in 2018. Another issue, advisors publishing ads that don't disclose the selection criteria for awards, or who created and conducted the survey, and the fact the advisors may have paid a fee to participate in or distribute the results of the survey. So again, if you've paid for it, you know, or you've done something to become a participant in the award, you do want to make sure you're disclosing the selection criteria, which leads us to our next issue that comes up with accolades and awards, and that's the misleading use of professional designations. For those of you with like CFP, CSA, you may recall that in your Part 2B, so basically the resume part of Form ADV for you, that you have to discuss what a CFA is, how one gets a CFA, how one keeps a CFA. And you have to disclose, if you're going to say that you had a CFA, you have to disclose whether or not that designation has lapsed. So again, you want to make sure that you've explained the minimum qualifications, and then, you know, disclosing whether or not that has lapsed, or if you're in the process of getting it. Again, the accolades and awards testimonials came up. So advisors publish statements of clients attesting to their services and otherwise endorsing the advisor. And that can be published in firm websites, social media pages, reprints of third-party articles, or pitch books. So again, if a third party has published something about you and it was beyond your control, that's one thing. But by reprinting it and providing it, you're taking control of that testimonial, and then it's prohibited. Now, I will say this. I was recently at a securities law CLE, and we had a bunch of the SEC staff there because we have an office here in Atlanta, a regional office for the SEC. And the issue of testimonials came up. And I will say that the SEC recognizes that several other industries have the ability to post testimonials. You know, I have the ability as an attorney to get reviews and post testimonials on my website and on my social media, and they recognize that it may be an outdated practice, and that it's something they need to revisit and look at and really determine if they should continue to prohibit the use of testimonials, since it is such a basic marketing tool for most other businesses. So I want to shift gears now. We've talked about advertising, a lot of the issues that come up with regulators. I want to switch gears and talk about regulatory filings. But before I do, I just wanted to see if there were any questions about advertising that have come up. All right, if you do have any questions, feel free to email me or message me, leila@myralawyer.com. Otherwise, I'm going to move on to regulatory filings. Now, regulatory filings, for the most part, are really going to be applicable to SEC registered advisors, because most times you're dealing with having a certain AUM before you trigger, or certain ownership percentages before you trigger any sort of form or filing that may be required of you. So we're going to start with Form 13F. So pursuant to Section 13F of the Securities Exchange Act and Rule 13F1, investment advisors use Form 13F to report to the SEC position information regarding certain equity securities. Specifically, every investment manager that exercises investment discretion with respect to accounts holding Section 13F securities having an aggregate fair market value on the last trading day of any month of any calendar year of at least $100 million must file a report on Form 13F within 45 days after the last day of each calendar quarter. These reports are publicly available, and in terms of determining whether you have at least $100 million in 13F securities, the SEC publishes that list quarterly, and it primarily includes exchange-traded equities, closed-end funds, ETFs, as well as certain convertible debt securities, equity options, and warrants. And you can actually find the list. I've provided you the website. You can find the list by going to SEC's website, and they'll have the list of the 13F securities. So as a Chief Compliance Officer, you want to make sure that if you've surpassed that $100 million and you need to double check at least to see of your total AUM, how much of that is a 13F security that may trigger your requirement to file a Form 13F. So Schedule 13D is another filing. It's a publicly available beneficial ownership report that is required to be filed by any person or group of people who acquire beneficial ownership of more than 5% of a voting class of a company's registered equity securities. A beneficial owner is any person who directly or indirectly shares voting power or investment power. Amendments have to be filed promptly, which means as soon as 2 business days, but pretty quickly, immediately, for material ownership changes. In certain cases, institutional investors holding between 5 and 20% of the voting class share, passive investors, and some other types of investors may be eligible to file an abbreviated version of Schedule 13D, and that is called Schedule 13G. There are some investors who are going to be able to take advantage of Schedule 13G. Most advisors that are passive and holding between 5 and 10% of the outstanding voting class of an issue will only need to file a Schedule 13G annually within 45 days after the end of the calendar year. However, once an advisor that is passive crosses that 10% threshold, the advisor will need to file an amendment within 10 days of the end of the month, as well as within 10 days after the end of any month in which the ownership increases or decreases by more than 5%. Separately, if an advisor manages a private fund that crosses the 5% threshold, then a Schedule 13D or G would need to be filed. And again, that generally is within 10 days after the threshold is crossed. Then the next type of filing that's out there for SEC registrants is Section 16 filings. So under Section 16, corporate insiders must file a publicly available statement of ownership with the SEC. Corporate insiders include officers and directors of a company, as well as any beneficial owner of more than 10% of a class of a company's registered equity securities. Qualified institutional investors, including registered investment advisors and other investors that hold shares as a fiduciary or for the benefit of third parties, are not considered a beneficial owner and then would not be subject to Section 16. However, a private fund managed by an advisor is subject to Section 16. Now, when it comes to Section 16, there are 3 types of forms. There's Form 3, which is used to make the initial filing. And if the issuer is already registered, it must be filed within 10 days of becoming an officer, director, or beneficial owner. Form 4 is used to report changes in ownership and has to be filed within 2 business days. Form 5 is used to report any transactions that should have been reported earlier on Form 4 or that were otherwise eligible for deferred reporting. Form 5 is due 45 days after the end of the company's fiscal year. Now again, as I mentioned earlier, these forms usually come up with SEC registrants and not necessarily with state registrants, but you should know about them because Section 16 could come up even as a state registered advisor. All right, let's keep it going. So finally we have Form 13H. So Form 13H is a reporting form required for large traders, and it's used to help the SEC identify large market participants, and then, by collecting information on their trading and analyzing their trading activity. The form is required. Let's see, I have a question here. Go ahead, Dave.
Layla, my question has to do not with this section, so we can hold it until the end of the presentation.
I'm sorry, say again?
My question has to do with a previous part of the presentation, not this section that we're on here. So we can wait till the end for my question.
Okay, no problem.
Thanks.
All right. Okay. So Form 13H is for large traders, and it's required of a firm effect transactions for the purchase or sale of certain securities for or on behalf of discretionarily managed accounts in an amount equal to or greater than the following two thresholds. There's 2 million shares or 20 million during any calendar year, or, and so the second threshold, 20 million shares or 200 million during any calendar month. These securities that would trigger this form generally include any security or class of securities listed on national exchanges or traded through NASDAQ, including equities and options, so common stock, ETFs, ADRs, etc. Again, this large traders Form 13H is really going to come up with your larger SEC registered firm. If you are an SEC registered firm, you're newly SEC registered, you're probably going to be most concerned with Form 13F, and that's definitely what you're going to want to check. Schedule 13D, 13G, Section 16, Form 13H. Generally, we see those happening with much larger AUM SEC registered firms. Now, these regulatory filings are why, as part of your code of ethics, you're required to get copies of statements for your employees' private securities transactions so that you can see if anyone in your firm would trigger any one of these reporting obligations. So it's really important as we learn all these different things that come up from a compliance perspective, how they interrelate and work, and why, you have the code of ethics requirement, and it's because you have these regulatory filings you have to make if you trigger these different thresholds for different ownership percentages. So those are the regulatory filings you should be familiar with. Of course, there's Form 80V, which all of you should be familiar with. These are the ones that most aren't, and they're filed through the SEC on their EDGAR platform, which can be a little confusing. There's 2 different EDGAR platforms depending on which form you have to complete, and they're working on trying to streamline that uploading process but it can be a bit of a pain in the butt too. And you'll want to make sure that you're familiar with how to do them. The directions aren't always completely clear, so this is probably a good example of why a consultant is really nice, because most of us have done these filings, are familiar with it, and know when certain securities would be triggered, and know how to look and see whose registered securities are part of the list that would trigger one of these filings. So this is the end of our presentation for today. I'm going to turn off the Q&A mode so that we can have any additional questions asked. All right, Dave, I think you said you had a question.
I did. And actually, one question came up on what we were just talking about. The Section 13F, that wasn't a single account that had $100 million. That was all of your accounts together where you have discretionary authority. If you get over $100 million in the list of F13 securities, that's where you have to file that.
Accurate. Yeah.
And do most SEC registered firms end up filing that report?
A lot of them do. Now, the ones that are like right around 100 million, probably not, because then it would require almost all of their AUM to have 13F securities. But as you grow, certainly we'll see most SEC registered firms having to file that 13F.
And just in general, what's a description of a 13F security?
So there's actually, I'll go back to the page. The SEC actually posts the list of 13F securities. And you can go and check it. I mean, they'll update it every quarter as securities come off and are added. That's the best way to check to see if you would need to file a Form 13F. Generally, they consist of, exchange-traded equities, closed-end funds, ETFs, convertible debt, equity options. But the specific list, the SEC publishes that, and it's available.
Okay. Oh my gosh, it's 541 pages. Okay. So like Google and Microsoft and Home Depot are likely to not be on that list, or likely to be on that list?
I would check the list.
Oh gosh.
Let's see. We're current list, third quarter 2018.
Yeah, okay.
Home Depot is on there.
Okay. So do people somehow extract this list into a spreadsheet and compare it against their thing? I mean, that seems like a major task.
It can be time consuming. I know ones that, their portfolios don't have a lot of securities and they're able to do it pretty quickly. Others have set up, some sort of technology platform, or they're using a custodian or someone who provides that service, and then they're searching that way. So there's certainly options available on the technology front. But usually, usually if someone's doing it the longhand version, so to speak, they've got an admin that's just going one by one through the list. Because it's done on a quarterly basis. So depending on the number of securities you guys are utilizing in any one of your portfolios, it just depends, how much time it would take. But I know some firms that are smaller that do it just one by one, and they have an admin that goes through it.
All right. I'll check with our custodians and with our CRM system to see if they have anything along those lines. The other question had to do with performance reporting. the guidelines you gave for actual performance and model performance and back-tested performance. Probably the thing that we're facing the most right now is trying to come up with a common language for inside of our firm for, we're a collection of acquisitions, and so we're trying to communicate to each other about performance of our different models and that kind of stuff. And the questions that you were saying that the SEC has an issue to when you're going to the outside are exactly the same questions that we're coming up against as we're trying to talk to each other. Where, is it, well, does this include that? Does this include this? Is it really comparable to mine? Is it really, are you really better or worse than mine? We're trying to figure that out. Do you find people adopt those same policies for internal discussions about performance just to be able to look at managing their portfolios and their models?
We see a mixed bag. There's some who just don't have the conversations, and they're the ones that we, end up coming to us for our legal defense services. A lot of advisors are afraid to use any sort of performance results, whether they're actual or model or back tested.
We're in that category. We generally try to avoid publishing anything or talking much about performance if we can avoid it.
I see a lot of advisors who feel that way because they're unsure whether they're making all of the proper disclosures. And so,
right.
I always just say, make sure you outline how you did the math. Does it include fees? Does it not include fees? Be very clear in how, your percentages were reached or how these result numbers were reached. And then providing very clear context. So, if you could go, for example, to your secretary or something and say, hey, here's a chart. Do you understand the disclosures? I think that's one way you could look at it, see if a layperson would understand what they're looking at and the context based on the disclosures you've provided. And a lot of times these come up in one-on-one presentations, so you have a client comes in. So maybe you say that for potential clients and clients who are more sophisticated and who would have a better understanding of what you're presenting to them. I mean, certainly if there's concern from your firm on how to utilize performance results, I mean, that's one restriction you could consider, that you only really use them with your more sophisticated clients. And then defining what that means.
Yeah, we definitely are. It's one of those things where it's a natural question for clients, especially new clients. Existing clients, they don't need to see other performance. They just want to know what theirs is. But a new client always wants that frame of reference, well, what should I expect, or what might this look like, or what could happen here, or what happened last year. They always ask those kind of questions. Not everyone, but, frequently that question comes up, and it's hard to know what to say, well, here's a client who has a similar profile to you, and this is what they did, but, it's really, that's the most disclosure that we ever do on. We don't publish anything with performance. But internally, where we're not going outside, we're just talking amongst advisors and investment committee, we still struggle with the same question of, how do we make this consistent? How do we speak the same language so that when we look at one performance result, it's comparable to the other? And these might be good guidelines just to follow the same, disclosures, so to speak, or understanding how we're coming up with stuff. So.
Yeah, I think it's great you guys are having the conversation, and certainly it'll provide the basic guidelines and help you create a procedure from a compliance perspective, so that when you guys do, if you guys want to actually put together performance results to provide potential clients, everyone's pretty clear on what that should include, and what kind of disclosures, and kind of how that conversation should go. I think that's a best practice. That's what I would love to hear. I know regulators would like to hear that too. And certainly if something came up and you missed one disclosure, the fact that you're having these meetings and discussing it is going to be a mitigating factor and likely will prevent any sort of disciplinary action versus an advisor who just puts it together and throws it out and has no process or no way of showing that they've discussed it or anything like that. So, I mean, I think it's kudos to you guys for discussing it. I don't think you should be afraid of using them. It's just a matter of making sure it's very clear, very even-handed, and then you're making the material disclosures and providing context.
Okay. That's good. That's the only question I have.
Okie dokie. Any other questions? All right, so I hope today was useful. I know advertising comes up a lot with our clients, especially as we see firms wanting to grow and go out into the e-world, the internet world, you know, the social media world, and start doing marketing. So more than ever, these issues come up quite a bit, and it's easy pickings for regulators to request copies of your advertisements, keeping in mind that that is a books and records requirement, that you are keeping copies of all of these different advertisements that you may be doing, anything written, anything recorded, your radio spots, your social media, your website, all of that, making sure you're keeping copies of it. So if there aren't any questions, we're going to end our session for today. Again, if you have any questions come up in the future, you can email compliance@myralawyer.com. Member of our team will respond. You can email me directly, Leila, L-E-I-L-A, @myralawyer.com. Or you can give us a call, 770-462-2118. You guys have a fantastic day. Bye-bye.